Hello, Con Law students. This is a lecture for Module 4 on Federal Legislative Powers. In this module, I'll discuss these topics. First, the doctrine of implied powers. Second, what's the deal with all these tests? And third, an update on a Supreme Court decision, National Federation of Independent Business versus Ceballos, from 2012. This case was decided just after your textbook was printed, so it was not included. First, the doctrine of implied powers. Your textbook doesn't clearly call it a doctrine, but it does include a very good section on the implied powers of Congress. I wanted you to hear the phrase doctrine of implied powers and know that the phrase refers to the constitutional principles on the interpretation of the necessary and proper clause. Let's look at the clause itself. I'm going to try to open the link here and have this in the module. Okay, this is Article 1 of the U.S. Constitution, which deals with legislative powers. Scrolling down to Section 8. The necessary and proper clause falls at the very end of Section 8. It reads here, Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So this last clause is at the end of a very long list of far more specific powers. So scrolling back up, you see Congress has the power to lay and collect taxes, to borrow money, to regulate commerce, establish a uniform rule of naturalization. These are all very specific powers. Then you come to the end and you just give Congress the power to make laws that are necessary and proper. So it's kind of an open-ended clause compared to the ones that preceded in the list. Now let me take you back to the PowerPoint. The clause itself gives Congress a power to make all laws which shall be necessary and proper, but it includes a modifying phrase for carrying into execution the foregoing powers. The courts have used that modifying phrase to place a reasonable limit on Congress's lawmaking power. As a general matter, Congress is the lawmaking branch of the government. The modifying clause must be the founder's expression that Congress would exercise its enumerated powers through the act of making laws. The problematic issue that you'll see addressed in the McCulloch versus Maryland case, and then again in the Comstock case, is how closely must an act of Congress be connected to an enumerated power. With the bank case, that's McCulloch versus Maryland, this is the case that involves Congress's creation of a national bank. And the state of Maryland pushed back against that establishment of a national bank, claiming that it was beyond Congress's authority to create the bank. In that case, you see that the law itself was really just one step removed from an enumerated power. The power to tax, spend, and regulate Congress is actually several different enumerated powers, directly connects to creating a national bank. So even though the Constitution does not specifically give Congress the power to create a national bank, that's just one step removed from the power to tax, spend, and regulate commerce. Another way to put it is this: the creation and operation of a bank is necessary for Congress to carry into execution its power to tax, its power to spend, its power to regulate, etc. So it kind of, you can fill in the sentence there or fill in the sentence of the language from the Constitution about that modifying phrase, carrying into execution. So it worked fairly easily with the bank case. I'll say it again. The creation and operation of a bank is necessary and proper for Congress to carry into execution its power to tax, spend, etc. So that one was an easier case to follow. The other case, the Comstock case, here the act of Congress was not so closely connected to any enumerated power, and that's why it became a dispute for the Supreme Court to resolve. The act itself was called the Adam Walsh Protection and Safety Act. It allowed, in case you don't know, Adam Walsh was a little boy who was abducted from a shopping mall by a sex offender, and ultimately and sadly, quite sadly and dramatically, he was murdered. His father has done a lot of work to strengthen laws against child sex offenses, and so this act was named after the little boy Adam. Okay, back to the lesson. The act allowed federal prison officials to send convicted sex offenders to an institution after the offenders had served their full prison sentence. There is no enumerated power that such a statute could directly connect to. Rather, we have to have at least one intervening activity. And so you might put it like this. Oh, I'm sorry. Let's see. There you go. Okay. We can put it like this. The Civil Commitment Law, the Adam Walsh Safety Act, is necessary and proper for carrying into execution Congress's enactment of criminal laws that forbid sexual exploitation of children, which is necessary and proper to carry into execution Congress's power to regulate commerce. So you see, there's more than one step. There's at least two. The Civil Commitment Law, the Adam Walsh Law, is at least two steps removed from an enumerated power, the power to regulate. And so jumping through these different steps is what made the challenger, the Comstock, the challenger, I believe he was a sex offender who was trying to challenge the legality of his civil commitment following he had served his time in prison, but was going to be committed to an institution even past his prison sentence. And he's challenging the constitutionality of the law that allows for his civil commitment. Anyway, so back to what I was saying. You see, it takes several steps to get from an enumerated power, the power to regulate, down to that civil commitment law. And that even this one probably sounds like a stretch to you. How does the power to regulate commerce give Congress the authority to enact criminal laws that forbid sexual exploitation of children? I mean, that alone is a leap, but it's based upon the, there are a variety of different tests the court uses to determine the propriety of a Commerce Clause power. But in the end result, the court has agreed that these criminal laws or the criminal behavior that's being regulated does ultimately have a significant effect on interstate commerce, because children are, that exploitation process often involves instrumentalities of interstate commerce. So the court has already made this first connection here from the criminal laws that are being enforced when criminals are put into prison back to the power to regulate commerce. But now in this Comstock decision, you have to make this leap, the civil commitment law, back to the power to regulate. You can't do it directly. You have to go through these extra steps. And so if you're just expecting the court to strike it down because of precedent, so the precedent was McCulloch, where they are just finding one, an act one step removed from an enumerated power. Comstock says you don't have to count the steps at all. So we're not going to worry about you're not going to worry about how many steps you take to get from an enumerated power to the present act. You're just going to look at the rational relationship based upon all the factors involved in the case, and that's how the court determines if the necessary and proper, the necessary and proper clauses being properly used. Speaking of tests, that's where we'll go to next. What is the deal with all the tests? So I'm pretty confident you've probably already read chapter 4 in the textbook before you listen to this lecture, and you probably noticed the discussion of the Commerce Clause and all the different tests that the U.S. Supreme Court has used for determining whether an act of Congress is authorized by the Commerce Clause. So we're shifting now to a different clause when we're talking about these tests now, but these tests are used for a variety of different legal issues. So it's not just a Commerce Clause thing that courts are using tests. They use tests for the necessary and proper clause. They use tests for tax and spend power. They use tests in a variety of different legal issues. We're just going to focus by way of example with the Commerce Clause and all the many tests that the court has used for interpreting the Commerce Clause. So what's the deal with it? First, let's start and just look at the tests that we've seen. Here's the language of the Commerce Clause. The Congress shall have the power to regulate commerce among the several states. That's Article 1, Section 8. That's one of the very specific enumerated powers to regulate commerce among the several states. But despite how specific that is, there have been many different tests that the court has used to interpret its meaning. Going back to the earliest incident was the Gibbons versus Ogden case involving steamboat licenses. In that case, the court used this test. Is the regulated activity commerce? The court was just trying to define commerce. Then we get the Schechter poultry case in 1935, and you can see a lot of time has passed between these two decisions. But then the test became, does the regulated activity have a direct impact on interstate commerce? And your textbook doesn't go in chronological order, so you'll see the next case kind of jumps back 30 years, the Swift decision. Is the regulated activity an essential part of the stream of commerce? And then you go to 1942, Wickard versus Filburn, involving wheat, the production of wheat. Does the regulated activity substantially or just affect that word substantially was sort of added on after Wickard, but it's part of the Wickard versus Filburn test. Does the regulated activity substantially affect interstate commerce? So you see right here, there's 4 different tests. And actually, there's another one that I don't even have in this list, but it's okay. I just don't want to overwhelm you. These are the 4 that your textbook highlights. But you see all of these tests and you might be wondering, what's the court doing? Why does it have all these different tests? Why are they changing over the years? The rubrics or the tests, you can look at them as like they were grading rubrics that a professor might use, or a legal formula with which courts will restrain themselves. Courts have to avoid making arbitrary decisions. They can't decide cases just because of how they feel at the moment. And so that often requires them to look at their precedent, look at how they've decided the issue in the past, and develop or formulate a test or a rubric that they can then apply in the future. So that's what they're for. That's why these tests exist. It's to avoid arbitrary decision making. But there's more than one test. And that's because different judges prefer different rubrics depending upon their judicial philosophy regarding the powers of government. as time passes, new judges get appointed. And those new judges have new judicial philosophies that will guide their decision making. So that's the reason why you're getting these different rubrics. It's just as the court, the makeup of the court, the judges change, but also because the politics of the nation changes. And that impacts the judges' judicial philosophy. So, for example, early America, when the Gibbons versus Ogden case was decided, 1824, this is just an example of the national government stretching its wings out and trying to look and see what its limits are. And in that case, you have a fairly Federalist, most of the justices in the court were still Federalist members of the Federalist. It was becoming a political party who believed that the national government should have broad powers. And so this is just an example of that fact that you have justices who are allowing Congress to kind of spread its wings a bit. But for most of the 18 and 1900s, Americans did not want or expect any government, much less their national government, to regulate private business. That would have been contrary to the laissez-faire economic policy that was guiding America's economy at the time. So the rubrics and tests that were used during this time period, the 1800s up to the early 1900s, will reflect that philosophy that Congress or even state governments even should not ever intrude on private business transactions. So you'll see the courts using this rubric that helps them maintain that restraint on power. But then comes the Great Depression, and that marks a very significant shift in the expectations of the national government. Americans become increasingly comfortable with Congress regulating economic transactions. And that's because the American people wanted Congress first to put a stop to the huge monopolies that were squeezing out competition from small businesses and driving up prices. But they also wanted Congress to pull the country out of the Great Depression. The American people wanted Congress to stop the exploitation of child and immigrant labor, to set safety standards for the workplace, to set consumer safety standards for the food that we eat and the medicines we take. And so as Americans became more comfortable with government regulation of private business, the new laws are getting passed where Congress is relying on the Commerce Clause to expand its reach, to delve more and more into the inner workings of private business. So in order to justify the laws, Congress had to rely on the Commerce Clause. And obviously there's going to be some pushback, which leads to these U.S. Supreme Court decisions. And in the end, the court had to accept the argument that commerce among the several states included many of the activities that before the Great Depression would never have been the subject of regulation. And that Wickard versus Filburn decision kind of seems to mark the outer limit of Congress's power to regulate commerce. We have not seen Congress's power expand any further than it did in that case. In fact, it started to come back the other direction. Around the 1980s, here is where you start to see the court implementing a stricter judicial philosophy about the power of the Congress to regulate commerce. And I'm thinking specifically of the Lopez decision in your textbook. You see evidence there that the court is returning to more restrictive stance on the Commerce Clause. And so in particular, that case involved non-economic activity. It was criminal activity was the subject of the law. But the court said that's too much of a stretch. The mere possession of guns is not economic and does not have a substantial effect on interstate commerce. So that's what the majority held. There was a dissenting opinion in that case, an important one that provides an alternate reasoning. So you'll look at that case and you'll see what I mean. But here again, I just want you to see the reason why we have the tests, what they're for. It is a good thing to prevent arbitrary decision making. Unfortunately, the tests change and things get kind of complicated because Americans' expectations change and the court's judicial philosophy changes in recognition of that changed expectation of Congress or of any government branch. The textbook provides the 3 questions. So this is the 3 Modern Commerce Clause criteria, and they're good to know. First, the first criterion, does the law regulate the use of a channel of interstate commerce? So there's your test. Does the law regulate or protect an instrumentality of interstate commerce or persons or things in interstate commerce? And then the one that was the subject of the Wickard versus Filburn case and those other ones on the last slide, does the law regulate an activity that has a substantial impact on interstate commerce? So those are the 3 that tend to be applied in the Commerce Clause decisions. But there are rubrics or tests used by the courts addressing a multitude of different legal issues, not just the Commerce Clause. And you'll start to see that as we move through additional modules in the future, looking at different government branches, looking at civil liberties. You're going to see these tests being used regularly. My next topic, actually my final topic, is just an update on a Supreme Court decision. So constitutional law update. There's a mention on page 107 of your textbook where the authors write that the Supreme Court has yet to rule on whether Congress has the power to enact universal health care. Even though it is not a universal health care program at all, I'm assuming that the textbook authors are referring to the Affordable Care Act, because when the textbook was being published, this case was pending before the U.S. Supreme Court and was decided right after the publication of your textbook. So this case is addressing whether Congress can justify the enactment of the Affordable Care Act through its Commerce Clause or its tax and spend powers. So I feel like this is an important decision that you really need to know. This one is very significant. I imagine it will definitely be included in future revisions of the textbook, but for now, I'll just try to explain it. First of all, we're dealing with the Affordable Care Act. You probably would know it as Obamacare, but that is really a misnomer. It was certainly not a direct enactment of President Obama's will. Although his administration submitted the proposal for a healthcare reform, the law that Congress ultimately wrote and approved took a very different form. And so the proper title to it is the Patient Affordability, Patient Something and Affordable Care Act, but we just should refer to it as the ACA, or the Affordable Care Act. The ACA required individuals, most individuals, those who meet a certain income threshold. So people who have a certain amount of money, not all people, but just people with a certain amount of money who can afford health insurance, have to get health insurance. It also required most employers to offer health insurance. So bigger businesses, bigger employers must offer health insurance. The act provided tax credits and cost-sharing subsidies for individuals to purchase insurance on a marketplace. And then it also provided for expanded coverage of Medicaid so that Medicaid would cover, and this is some technical language, childless adults earning incomes up to 138% of the poverty level. I'll explain that a little bit more further. Insurers were prohibited from denying coverage to individuals who had pre-existing conditions. And then insurance companies are required to offer a set standard of benefits And then there are other things affecting premiums. So it's a big bill. It's a big piece of legislation with a lot of different provisions in it. The main point, though, of the Affordable Care Act is that it is a response to demand from the public. This is the late 1990s, early 2000s, and the cost of health care is a huge problem, still is today, even. But at the time of President Obama's administration, this would have been 2008 through 2016, many Americans from all sides and places on the political spectrum were demanding that the national government provide a solution to the really like skyrocketing cost of healthcare. It's really expensive. So the Affordable Care Act attempts to lower healthcare costs by spreading out those costs across a broader risk pool. But to broaden the risk pool, you got to get more people in the marketplace, more people in the healthcare market. More people have to purchase health insurance in order to broaden the risk pool. So the Affordable Care Act is an attempt to create financial incentives and an infrastructure so that more people can be covered by health insurance. That broadened risk pool included the so-called individual mandate. So people who could afford to get private health insurance had to either purchase it or to pay the government a type of fee through their income tax submissions each year. Along with that broadened risk pool, the Affordable Care Act required states to expand Medicaid coverage. And I mentioned I was going to get you back to this. Medicaid is a welfare program that pays the medical bills for people in the lowest income bracket. It was initiated during President Johnson's administration in the 1960s. It was a much desired, a great program that President Johnson saw a need for, Congress supported, and it helped get many more Americans who before could not afford to go to the doctor. Finally, they're able to go to the doctor and get the medicine they need. And the way they do it is by applying for Medicaid to see if they qualify for it. If they do, the national and state governments will pay for their health care. They'll pay their health care bills. And notice I said together the national and state governments pay for it. States have always been active members in the administration of the Medicaid program. Now, under the Affordable Care Act, Congress asked states to expand the coverage of Medicaid so that more people could be covered. And then it would contribute money to the states to help fund the increased coverage. But if states refused to expand coverage, Congress would not continue to send states the matching funds to cover the cost of Medicaid. That's where the court case comes in. Opposition to the Affordable Care Act grew during President Obama's administration, and an organization, it's the National Federation of Independent Business, they filed suit against Catherine Sebelius, I think I'm pronouncing it correctly, Sebelius. I apologize if I have that wrong. She is the head of the Secretary of the Department of Health and Human Services, and the NFIB is challenging the constitutionality of the law. And so for this learning module, I want you to read an article. You don't have to read the whole decision unless you want to. What I've done is attach a link in the learning module to an article about the court's final decision. The article is going to give some context for the decision, and then it's going to provide some excerpts from the majority opinion, a partial dissent, and then a full dissent. So please read that article carefully so that you can understand the judge's perspective and philosophies on the power of Congress to regulate through both the Commerce Clause, and they also discuss the tax and spend powers of Congress. So it's got a lot in there that's very relevant to this learning module that you really do need to read. Okay, that's all I have. Those are all the topics I plan to cover for this learning module. But if you find anything else in the chapter 4 of your textbook that you would like me to explain further, please send me an email. I'll be happy to do that for you.